Up next, we have the privilege of hearing from Honorable Justice C V Bhadang, President of the Income Tax Appellate Tribunal. Ladies and gentlemen, with a distinguished career in law and taxation, he has been instrumental in shaping tax jurisprudence and ensuring fair and just proceedings of tax matters. Please welcome him with a generous round of applause.
The dignitaries on and off the dais, delegates, invitees, ladies and gentlemen. It is really a matter of great pleasure for me to be a part of the inaugural ceremony of this day-long Congress organized by Tax India Online. At the outset, Dr. Shailendra Kumar, he is not to be seen here, in fact. I only met him when I came here. The founder, editor, and TIO of the TIOL and his team of organizers deserve to be congratulated on the occasion. It was on the last of such occasion in 2024, I was told that a book titled China's U-Turn Towards Forbidden City, authored by Dr. Shailendra Kumar, was released. He had been kind enough to spare a copy of the book to me when he came to invite me for this inaugural ceremony. I have found that the book to be quite resourceful on the geographic, geopolitical, and economic model of China, except that I was required to keep a copy of the Oxford Dictionary by my side while reading the book. It was really a pleasurable experience. I had an occasion to go through the subjects chosen for the 5 technical sessions which are lined up for the day. And I think they are extremely relevant and important in the contemporary times. 2 out of the 5 sessions are rightly devoted to the subject of goods and services tax, which is, as compared to the income tax, is a new subject by introduction of the GST. The subjects also include the legal implications of the retrospective taxation, to which reference has already been made. The opening technical session justifiably focuses on the revamping of the Income Tax Act by virtue of the income tax bill which has been introduced in the Parliament and is presently stated to be before the Select Committee. Significantly, one of the sessions also covers the important subject of ease of doing business in the context of new age digital economy. It has been the common experience that there is a continuous race between the development in the fields of law and those in the field of technology. And more often than not, it is the technology that overtakes law, and eventually the law has to keep pace with the disruptive changes brought about by the advanced technology. My experience, and in fact the first experience with this kind of the disruptive technology, which has a very wide spread influence on the law, was by when the Negotiable Instruments Act was amended by introduction of Section 138. And the dishonor of checks was made a punishable offense, which was not before that. So, and thereafter there was introduction of these MICR checks and these banking where you can present a check in any of the branches of that particular bank. And that led to a significant litigation as to the territorial jurisdiction of the judicial magistrate where the complaint under 138 can be entertained. And that was ultimately settled by the Supreme Court. So these are the kind of the technological changes which have got very wide spread influence on the development of the law also. And I think the emergence of the digital economy is one of such technological advances which is bound to generate substantive amount of legal disputes. India, with its fast-moving pace of infrastructure development and business and commerce, has made a significant strides in the world of economic order. We talk of the country aspiring to become the 3rd largest economy and a developed nation by 2047. And as the experience goes, this is bound to throw new challenges in the field of the fair and equitable resolution of tax disputes. I think the Income Tax Appellate Tribunal, which in fact I represent, being the oldest tribunal in the country, is at the crossroads, facing a watershed movement with the attempt to revamp the direct tax laws. If you see the chronology of the events, the income tax was first introduced in the country perhaps in the year 1922. And 20 years thereafter, the tribunal came into existence somewhere in the year 1941. And 20 years thereafter, in 1961, the first Income Tax Act came into existence. So that was the first watershed movement which the Income Tax Tribunal must have faced way back in 1961 when the new tax law came. And now we are on the verge of another tax law coming into force shortly. Another reason why the tribunal is at the crossroads is also on account of the framing of the Tribunal Reforms Act of 2021, as all of us are aware, which has brought significant changes in the composition of not only the income tax tribunal, but near about 17 tribunals are governed by that act. And unlike before, now the appointments before the tribunal are made tenure posts of only 5 years. Of course, the matter is sub judice before the Supreme Court, but the question is only whether it should be 5 years or 4 years, because initially the government had proposed that it should be only of 3 years. So this is another reason why over a period of time, the act will lead to gradual changes in the composition of the tribunal over the coming years. Right now, it's very early to say anything or to comment anything on the Reforms Act of 2021, because speaking for the Income Tax Tribunal, we had only 2 batches. The first batch came in 2021, which would be retiring in December, and another batch has joined recently in 2024. At the administrative and judicial level, we are taking all the efforts to gear up and prepare our resources to face the challenges in the coming years. This is done at various levels by filling of vacancies, human resource development, and of course, integration of the advanced technology in the working of the tribunal. We have introduced e-filing as per the mandate of the Honorable Supreme Court. We have introduced paperless courts and facilities for virtual and hybrid hearing, which are very well accepted by all the stakeholders. I am happy to tell all of you that in the last 5 years, pendency of the cases before the tribunal has gone down to about 43,000 on 1st of January 2025 from the earlier 90,000 in 2020. This is a reduction of more than 50% of the pendency before the tribunal. Undoubtedly, this is because of the active cooperation of all the stakeholders. I don't propose to stand between you and your technical sessions, because I was told that we are already running late. So undoubtedly, I hope and trust that the deliberations in the Congress will go a long way in finding solutions to the complex and vexed issues in the tax disputes. I take this opportunity to express my gratitude to the organizers and his team for inviting me. Thank you.